Good afternoon. My name is David Siegel. I'm introducing myself, one, for the room, and two, so everyone looking at the weird spelling under my name on the Facebook screen knows how it's pronounced. So, good afternoon, and thank you for having me. Before I start, I wanted to say a couple of things. When I came up here a little bit earlier, there's a few people that really deserve recognition for what I do, and it ties into what I'm about to say. Julianne here does so much work, and she's so great to work with, and she deserves so much credit, and I'm very glad she's here with Second Amendment Foundation. I want to make sure that was said. My office is in suburban Chicago, and my practice with Second Amendment Foundation, while not limited to the state of Illinois, involves a number of cases in the federal courts in Illinois. Part of what I do also involves, I'm counsel for the Illinois State Rifle Association, and I can tell you, especially for the members and officers that are in the room here, that they are just a great organization for all the support they provide for the lawsuits, as well as all the other work they do behind the scenes, working to promote and protect Second Amendment rights. If you are an Illinois resident in this room and you're not a member of Illinois State Rifle Association, you should be. And if you are in this room because you're visiting, you want to hear what the hubbub was about, and you're not a member of Second Amendment Foundation, you also should be. The work these two organizations do, I can tell you firsthand how amazing that it is. Also, a shout out, I couldn't say ISRA without throwing a shout to the Illinois Carry folks. They work so hard. Valinda, Mike Rowe, they do so much work behind the scenes also, and helping me behind the scenes with the litigation. So with that said, what is the litigation? Well, the first was, I referenced it a little bit earlier. It involves, it's the case of Culp versus Madigan. It is the years-long struggle, ongoing struggle to obtain the right to file a concealed carry application here in Illinois for non-residents of 45 of the 50 states. Illinois allows only 4 states to file even an application. They don't allow people to even try and prove themselves. They just say, if you're from this state, 45 of them, we can't trust that you are a qualified law-abiding person, and we're not even going to give you a chance to try. We believe that is unconstitutional. We argued this before the 7th Circuit Court of Appeals on Thursday, and we hope that the result is going to be favorable, and we will keep you up to date, I guess in Phoenix, if nothing else, about how that went. 2 other cases that are related by the Venn diagram, but they have some overlap, but they're not quite the same case, are the 2 assault weapon cases. One is called Easterday versus Deerfield, and one is called Wilson versus Cook County. In 2013, when the state passed the concealed carry law, it also redid the Floyd Act, and it basically passed what we'll call an assault weapon law. And when it did that, it also said that local governments have 10 days to pass their own laws if they want. Otherwise, this law, the state law, is preempting. It's taking over, and the local governments are not allowed to pass anything new. Deerfield did not get that message. So they had, within the 10 days, they passed an ordinance that regulated assault weapons and in large capacity, to some extent, large capacity magazines, and said that you can have them, but here are the restrictions and the requirements. Now, love it or don't, that was the ordinance they passed. And this past year, they went and just passed, after the Parkland tragedy, they went and passed an assault weapon ban. They claimed that it was merely an amendment to the previous ordinance, which in the state law was allowed, but we argued successfully that it was not an amendment, it was a brand new law, a brand new gun ban that the state was not allowed to do. And so far the court has agreed with me and with the attorney in the consolidated case called Wambacher, Gun Save Life versus Deerfield. And the court entered a temporary restraining order, which is still in place. The penalty for violating this ordinance, by the way, was up to a $1,000 a day fine, plus confiscation and destruction of your firearms. So we are briefing right now a preliminary injunction, and we're going to argue that in a couple weeks, but nothing has changed. The court has ruled in our favor. The legal arguments haven't changed, so we're hopeful that the court is going to continue to rule in our favor, at which point the village will probably appeal, and then we'll see what the appellate courts think about it. The other case is Wilson versus Cook County, which is just an assault weapon ban altogether. We filed that in an opportunity to show that the case is different from the Friedman versus Highland Park case, which was, I think Don referenced that. It's another assault weapon ban case that the Seventh Circuit upheld and the Supreme Court declined to take, but we think this case is different. We think it's distinguishable, and the district court disagreed with us, and so it is up on appeal right now as well, where we are arguing not only that the case is distinguishable, but also that the Friedman decision was wrong, and hopefully the court will take us up on hearing that argument. There are two other cases. The next category of cases are what I call the foster care cases. There's cases in Illinois, and then there's a case that I have in Michigan. The first case, the Illinois case, is called Schultz versus Walker. The second one in Michigan is called Johnson versus Lyon. Basically, it is a home firearm possession ban, a functional firearm ban if you are a foster parent. We are arguing that that is an unconstitutional violation of Second Amendment and equal protection rights. And in the Schultz case, the court had denied a motion to dismiss, so we are getting ourselves geared up for trial. The court actually wants us to sit down, next week, and see if the parties can actually come to a settlement. So I guess we'll see what happens with that. Otherwise, it's going to wind up at a trial. And the judge in the Michigan case denied a motion to dismiss as well, so we are going to proceed with that. We're going to proceed with the Michigan case as well. I can tell you that there is an imminent case in another state. I'm not going to say which one, but I've now narrowed it down to 48, that we're going to be filing over the same thing because winning firearm lawsuits, firearm freedoms, one lawsuit at a time, and so there's someone else that their rights are being violated, and so we're going to step in and try and do something about that. Related to that is the Illinois case of Miller versus Walker. This is a ban on functional firearms in daycare, home daycares. Now, I want to make it clear for people watching this. This is not, none of these cases, the foster care, the daycare case, this is not about, I have my Second Amendment rights, and if I want to leave a gun on the coffee table or the toy box, I'm going to do it. It's not that at all. Actually, what the plaintiffs want in these cases are very modest. They want to be able to have a firearm if they want, to have on their person if they so choose. If they have carry permits, then when they go out, they should be able to do that. And they have in Illinois and in Michigan as well what is called safe storage. Other places have it as well. It's not a new term, where you have to have a firearm locked up, unloaded in one safe, and then in a separate location, the ammunition. Well, what good does that do you when someone breaks into your house in the middle of the night? So all we're asking for is the right to, okay, fine, if we're not carrying it, it's not on the person, lock it up, but we want it to be locked up loaded so that if you actually need it at a moment's notice, it's available. We don't think that these are very outrageous requests, and hopefully the courts are going to agree with us in those cases. The next case is the public housing case down in East St. Louis, Illinois. A woman who I'm calling N. Doe lives in a housing project. She is told that you cannot have a firearm in your residence. If you do, we will evict you. Ms. Doe has an ex-paramour who went to jail for very violent crimes and has threatened that if he ever finds her, he's going to kill her and her children. And the housing project says, you don't need a firearm in your residence, we can protect you. So we are in court right now over whether or not someone who is in public housing because of limited financial means gives up their Second Amendment right because of that. This case, it might sound familiar. There was a case back in the Central District of Illinois, which I won back in 2012, I think, called Win-Bigler. But the Southern District, the housing project in East St. Louis didn't get that memo either. So we, really frustratingly to me, we find ourselves litigating this same issue. How am I in? I'm good. All right. I bring up Illinois because there's a number of issues that are sort of unique to Illinois residents that I wanted to point out for ISRA, so that if you're aggrieved or you know someone that's aggrieved. Long and short of it, because time is short, is the FOID and the Concealed Carry Review Board cases. The system is very, very flawed. The state is very quick to take away gun rights, and they're very, very slow to give them back. You find yourself arrested for something that doesn't matter that you didn't do it, but you find yourself arrested, you're going to automatically get a revocation notice of your FOID and your concealed carry rights from the state, and you have to go turn in your card. When you're acquitted of that charge and you want your FOID or concealed carry, you have to undergo a whole bunch of paperwork, submit it to the state police director, which is under no timeline to actually respond to it. And then when I usually get a call is about 8 to 10 months later when they've heard no response. And sometimes I can get a response, and sometimes you got to go to court to force a judge to get them to act. Concealed Carry Review Board, same thing. They get extension after extension. Any law enforcement can file an objection. Doesn't matter if it was some minor thing 20 years ago that you were acquitted of. Doesn't even matter. An objection will trigger a referral to the review board. There is no timeline for them to act, and if they do not, you can't get the records. You don't get a hearing. You might get a chance to put something in writing, and if they deny you anyway, your only chance is to go to court under the Administrative Review Act, where the bar for an applicant is so high to get over, it's practically pointless. That system needs to be changed. And nobody here is promoting the people that shouldn't have firearms to get them, but the system just unfortunately excludes too many good people, and it needs to be changed, and there needs to be some kind of timeline put on, and that's something with SAF and with ISRA we're working on. There are 3 cases going on involving gun stores and gun ranges that were denied. And those are basically damage cases. The municipalities have basically agreed, or the courts have ruled that their Second Amendment rights were violated by not being allowed to open. The gun range case, the court has actually disagreed with that and said that notwithstanding Ezel, there's still no right to, a municipality can still zone a gun range out of existence. And so we're continuing to fight that. It might wind up on appeal, but there's a motion to reconsider that the judge hasn't ruled on, so maybe he's going to let it go forward. But it's a little disheartening, and really is why diligence is required, that these cases, that these really big victory cases, and that's really awesome, but it's not the be-all, end-all necessarily, and other courts will try and distinguish and pick apart. And if they can find a reason to rule against Second Amendment rights, they'll do it. And so we have to constantly be vigilant about that. The Oster case. There is Kyle was up here talking as a Parkland survivor. You know that after Parkland, there were a number of school walkouts that were scheduled across the state, across the country, all on a same day, same time. Well, as you heard, not everyone necessarily agreed with the viewpoint of the majority. And there is a girl, Ms. Oster, up in Rockford, and when she wanted to hold up different signs at her school walkout on the football field that talked about hardening schools and being pro-Second Amendment rights, the administrators and the principal ostracized her. They pushed her off to the side. They said, "You can't go over there with the rest of the kids," and then made her and her small group of friends stand there on the corner by the exit while all the other kids walked past them, yelling insults and other pejoratives as they walked past. Now, some of that, of course, is high school, but most of it in this case was because the administration sent the signal that this girl's viewpoint was wrong and different and did not deserve the same attention and respect as the majority. So we are in court right now up in the Northern District in Rockford for violation of her First Amendment rights. It's one thing to talk about respect, but everyone has to be respected in their viewpoint. Don mentioned the Young case. SAF is going to be working on an amicus brief in support of as opposing the en banc and supporting the Ninth Circuit panel decision of open carry. SAF and its supporters felt it was very important to stand up and step up and do this, so we're going to be doing that. Finally, just a brief word about anyone who's heard me talk before in these kind of panels has heard me talk about the seemingly never-ending saga of the Mariana Islands and the gun ban that was struck down there. When last we spoke, I believe, the government had given up. They had lost its summary judgment. They said, fine, we'll pass a new law, and they paid off the plaintiffs. They paid the attorney's fees, and they were all set to move on. The Tanapag Middle School PTA moved to intervene so they could appeal. When the court denied that, they moved it to the Ninth Circuit. So we had to argue that back in June, and the Ninth Circuit quickly denied that request. They turned them down, but now they might be seeking en banc and dragging this out, so maybe that's something else we'll be talking about in Phoenix. The last thing I want to mention, I'm using Don's extra time. Yeah, it's all good. Last thing I want to point out, especially for you Illinois residents, but this could apply, I suppose, just about anywhere. I represent a person in a county court. I'm not going to name his name. He has a concealed carry permit. He was confronted by a much larger, younger someone who got angry at him and started advancing toward him in a very threatening manner. This gentleman, who was carrying at the time, he lifted out his firearm from his holster and he put it down to his side. The person immediately, the would-be threatened, the attacker, immediately backed off. And my client put his firearm back in his holster and calmly walked away, and that should have been the end of it. But the attacker went to the police and said that this guy pointed a gun at him and threatened him. And so now my client is being charged with aggravated battery for what is, in all accounts, the most modest, the safest manner of self-defense with a concealed firearm perhaps ever. So I want want that, I just wanted to point that, and hopefully he goes to trial in November, and hopefully, you know, we're not backing down from it, and we expect to prevail for this gentleman. But I want to point that out as a cautionary tale that, you know, that the authorities, the court, the prosecutors are moving forward with it, the police arrested him, and so I want that as a cautionary tale that what I said a few minutes ago, that just because we've won these cases, just because we won Moore versus Madigan, does not mean in the next case or in the next or at a local level, it doesn't mean that all of a sudden it's going to be held up as the high and mighty gospel. And we always have to be diligent, and we always have to be on our guard to make sure that our rights are protected. And we'll continue to do that, and we'll tell you more about it in Phoenix, I guess. Thank you very much.